Hello, everyone, and welcome back to Ask the Attorney Part 18. I am Maya Engel, joined once again by Mary Ann Wehr. Normally, it's just the two of us, but today we have a special guest to talk about titling assets. Tom, thanks so much for joining us on Ask the Attorney.
Thank you so much for having me. Appreciate it.
Yeah, do you want to tell us a little bit about what you do?
Yeah, so I'm a financial advisor. I work at Stone Path Wealth Management, and I actually started off my career in taxes. So before I made that shift, I got a good understanding of how taxes work, and still do taxes today as part of the practice. So I'm hoping to bring up some things today and ask some questions to Mary Ann. Some things that I see quite often that people are asking me, and sometimes a little too late. So hopefully we'll be able to share some of that information and stop people from getting into things where they have to get more attorneys involved or more financial advisors involved to get the problem fixed. So.
Yeah. Tom, it's great to have you here today. And sorry, Mary Ann, I just want to say, in case people are new here and you don't know Mary Ann, she is an estate planning attorney here in Northern Michigan. She has been our attorney on who we've asked questions on Ask the Attorney for all the segments. And I do want to remind people before we get into tonight's topic that if you have any questions at any point for Mary Ann or for Tom about titling assets or really just about anything, you can leave a comment in the comments below and we will take a pause in our conversation and get to those comments. But sorry, Mary Ann, I kind of cut you off there.
No worries. I interrupted. I was going to say, instead of ask the attorney, this may be stump the attorney tonight.
Mix it up a little bit tonight. So let me just start by asking, and this is something that right before we went live, I said, is this going to be a dumb question if I ask this? But I think we have to start here. So what exactly is titling assets? What does that mean?
Want to take that, Tom, or would you like me to?
No, go ahead.
Okay, so titling assets. So we've spoken a bit about titling assets, probably in almost every conversation, but we also spoke about it a lot when we had a segment on funding your trust. So it was trust funding your trust. And really what the topic there was, even though it may have sounded a little more esoteric than it was exactly this. It was titling assets either in the name of your trust or for your trust to be the beneficiary of those assets. And we were talking a lot about what happens if you don't title your assets appropriately. But tonight we're going to broaden that conversation, get a little bit far away from just funding your trust to kind of a lot of things that can happen, can go awry with funding and with titling. And it all sounds so simple until you really start putting pen to paper and see the errors. And we want to help people step away from pitfalls if we can.
So then going off of that, what are some common mistakes that either of you have come across when it comes to titling assets?
So Tom, do you want to talk about, what people sometimes do with their property, like their houses? And
Yep. So I've got a couple of examples that I've ran across with clients. One of them was what happens if a client of mine adds a child to their primary residence or to their home? What they just did without them really knowing, because a lot of times from the client's perspective, they're not doing anything wrong. They're just trying to make it to where if something happens to them, this house goes to their son or child. And I know that there's some better ways out there that you could probably tell us about on how that should normally be done.
And that's a common question. People say, hey, I just want this to go to my son or my daughter when I die. Can't I just put them on the deed? Well, the answer is sure, you can do that. I mean, you can do that, but you really need to understand what the impact is of doing that. And the legal guidance, as we talk about often here, would be on a case-by-case basis. So I'm not giving legal guidance here, but I'm just saying, here's what can happen, right? So once a person is on the deed of the house, your son, your daughter, your sister, your brother, when they're on the deed of the house, they are an owner of that home. So they share in the ownership of the home, which means that if they have to declare bankruptcy because something bad happened in their life, your home is looked at by the bankruptcy court as part of their assets. So your home might need to be sold to pay their debt. I mean, that's not a corner case. I mean, that's a real true case. It might not be bankruptcy per se. It may be a lawsuit. I pull out on South Airport Road every night, and sometimes I get a little impatient because it's just a steady stream of traffic that never ends. And, I could pull out one night and not have enough room to do it, end up in an accident and cause an injury or a death in the other car. What's going to happen next is a lawsuit. They're going to look for all of my assets. What can we get out of this troublesome person that pulled in front of traffic? Mm-hmm. And if I'm on someone's deed, just for convenience, that is an asset that this creditor, this lawsuit, can tap on and pull from. So those are a couple of very, people think, that's not going to happen, but you don't know. Those are two things. But the third has to do with, there are easier or better ways, maybe, to give that property to your son or daughter without risking it while you're living in it. And I guess the other thing I would say is, how do you know if you yourself might come to a situation where you just want to sell that house, get the money out, downsize, move to another state, whatever? If you've got somebody else on your deed, you're a little bit locked unless they say, okay, mom, sell your house, right? They can hold you down. So there are better ways, I think, than putting someone on your deed. And one of the other topics that we've talked about, people have asked about even, is the value. It's called a step up in basis. It means mom bought the house for $100,000. The house is worth $400,000 today. When mom gave Junior a little piece of it, she gave him a little piece of $100,000. If when she dies, he wants to sell it, and now it's worth $600,000, he will need to pay capital gains tax on the difference between the $100,000 and the $600,000. Capital gains tax right now is about 20%. That's a big bite. That's a lot of money. Where if we used a different method for getting that property to Junior upon the death of mom, that her son could get what's called a step up in basis. So when he takes the property, he takes it at $600,000. If he sells it tomorrow, he has zero capital gains tax. And if he sells it in 2 years, he only has a difference between $600,000 and whatever it's worth at that time. So there's a lot of pitfalls people can step into if they just deed their house to their son, because it seems simple.
Yeah. Yeah, those are a lot of the same things that I try and bring up, but as an attorney, you get to see it from a different perspective. One thing that I always try to bring up is the tax thing. It's always best to try and inherit something than to try and gift something, because that's technically what you're doing. You're gifting, right, part of that asset to that person. So on that note, let's say I go ahead and I did do that, right? Is there any way I can go back and undo that? Or is that pretty much done? Or, am I stuck with the consequences? Do I need to go file a gift tax return and do all that? Or is there a way you can undo this as well?
Well, so you just brought up a gift tax return, which does need to be filed once you've gifted. Now, if you're talking about tomorrow, you say, oh, that was a mistake. Or 2 years from now, oh, it was a mistake. You now have another owner on that home. Mm-hmm. And that owner, your son or daughter, needs to agree with conveying their share of that home back to you. Okay. That can happen. But that, I've seen case after case, read case law after case law, where son says, no way, you already gave it to me. End of story.
Yeah.
So that is one way of undoing it. You don't undo all of the consequences, but depending on how quick to redo it you are. But for the most part, you're kind of stuck. You have another owner on your home. That other owner, by the way, here's another, they are now, if you've given it to them, what's called tenants in common, they own an equal half. They may get a divorce. Now guess who owns the, part of your home, right? Your son's ex-spouse. So it just the tangled webs we weave. It's hard to undo. I don't, I would avoid getting into that position.
And do you guys have any hints or tips about titling business assets?
Yeah, that's one I get quite often is, I always try to work with clients on, thinking of a business entity as kind of like a twin of yours. Think of it as a separate person, right? It's not something that you can just toss things in between, but sometimes business owners will, have an S corp or something, and maybe they'll open up an LLC and move assets from one business to the other by, just kind of pushing it over there and retitling. I know, like, tax wise, there's stuff that you have to track, like depreciation and stuff. So that's going to be difficult if that's how you're moving it. But what are some other things from like the legal perspective that they should be looking at as well?
Well, I think, again, fair market value, you're moving assets, right? And I think this wraps right into the accounting. I think it wraps into your discussion of tax, but you're moving an asset. So if I have a $100,000 asset in company A and I moved it to company B, I need to do the accounting for that. It needs to be moved over with the appropriate depreciation. That's why you've got an accountant and tax guy, right?
Yeah. So company B would take the money, the $100,000, right? You'd have to fund company B, and then company B would take that money and purchase it from the other company. That's how you're okay.
Yeah, I think so. I think that's pretty much, you put it on the books that way. And the other thing is when you're talking about titling assets for an LLC, it is not uncommon, although it is becoming more complex to do it because of something called the Corporate Transparency Act, but not impossible, to put that LLC into a trust, and put the actual company into a trust. And the benefit you get from that is the trust can now operate. It has direction as to who can operate, who can sell, how to sell that LLC. If it is sitting outside of a trust, there needs to be some kind of an operating agreement in place that allows for a member-managed company. And oftentimes LLCs are just almost solo proprietors who have formed under an LLC umbrella, trying to give themselves limited liability. And it's hard to continue operating or even selling that LLC unless it's in a trust. Because there just are no mechanisms for that. It's somebody else's property. If it were my property in an LLC, I died, there's no provisions for it to continue as an entity or even be sold until it goes through the probate process. So there's a stalling of that asset. So there are important, and again, case by case, right? But you look at what people's goals are. Now, some LLCs, maybe you don't worry about it. But certainly the reason you put something in an LLC is to make a separate entity from yourself. And then, as you know, Tom, the legalities of keeping it separate, no commingling of money. Don't go into the LLC pulling your paycheck out without accounting for it. But you start to pay your credit card bills and you start to put gas in your tank, and then you're making that LLC merge with yourself, and you've lost the limitation on the liability that you've attempted to gain through the LLC. You've what is termed pierced the corporate umbrella. And so then you lose the benefits that you were attempting to seek. And sometimes that corporate umbrella is pretty thin anyway. You can pierce it pretty easily. So people need to be careful about LLCs, operating them. They do need to think about, like you say, it's a twin of yourself, but it's not you. It's another legal entity. It passes its money over to you, unless it's, of course you can file it as an S corp, but whatever it makes in the end, it 1099s to you pay taxes on it, but you need to be careful not to commingle.
Yeah. Yeah. And I guess another quick note on that would be, that you will want to talk to a professional about this stuff, because if something happens to you and that business gets transferred through the estate process, different things owned by different types of entities are going to be treated differently inside of those entities as well.
Exactly.
So how you title those, and depending which, whether it's under an LLC or under an S corp, it could be the same thing but treated two completely different ways. So
Right.
I want to make sure you talk to somebody about your specific situation in that.
Exactly. And you might have a partner, right, Tom? I mean, you might have a partner. You have an LLC, and it's a 2-member LLC. It's got a partner. Now, is that partner, I think maybe we'll talk about this, but is that partner wanting to purchase your share? In other words, pay your family for the value of your share? Is the partner okay with your adult son taking over your share and operating the company along with him? There's all kinds of discussions, points, and thought processes. And we've talked so often, Tom, about how this really does wrap into estate planning, how your business succession planning goes.
Mm-hmm.
And again, case by case, you really need a room full, right? Having a lawyer, having a financial advisor, your tax, the person who understands tax inside and out. Your CPA is probably that person, but insurance guy even. So you need a good, solid team of folks to help you really structure your business as it grows, so that you avoid legal pitfalls, tax pitfalls. Whole gambit.
Yeah, it's really all around the best for the client if those people that you just mentioned are working together. I mean, if all of them are familiar with the same client and they all understand the client's goals and objectives, then they're all kind of working together, making sure that, because each area is going to overlap. Tax is going to overlap with your investments and how your business is running. And so having everybody on the same page and working with professionals that are working together is really helpful for the client as well.
It really is. It really is. It's almost, you could take a small business and put all the pieces into it that a large business has by just having a team of people working together, right? Yeah. So you might not have a room for a chief financial officer or for a general counsel, or for a risk management group, but you can bring that all together in a more creative way, I'd say.
Yeah, absolutely.
So not all of us have businesses, but I think most of us have some toys, whether that's a nice car, maybe a snowmobile, maybe a new boat. So do you have any guidance on about toys when it comes to titling those assets?
I do. And I don't, I don't do a lot of this. Sometimes when something has been financed, it's a little more difficult, but putting I would call it a hot asset. It's an asset that you can get in a boat wreck and wreak a lot of havoc for whoever the occupants are, whoever you hit. And it may not be easy to ensure the level of destruction that might be. If you are able to put that boat into, I'm talking about, this is a boat that's got 2 400, horsepower engines on it and it's just scooting. You can put that boat into a irrevocable trust. It is its own entity. The trust owns it, and it has all of the liability for it. So you've paid the insurance, but the only place that somebody suing that boat can get to is basically that trust. And that is a place that it's a little hard to put something in there. Many financing companies are going to fight you a bit on that because it is irrevocable. But that is an idea. Is that what you were kind of thinking, Tom, was asset protection and that?
Yeah, that's, the way you phrase it, you said you don't do it very often, but I think it still brings a good point about how titling can really limit liability, right? And that's exactly what you're doing right there is you're just limiting liability to where it can't get to you personally.
Right.
Or if it does, maybe you have other insurances in place, but the key point there will be, it's protecting liability. Same thing on you can take liability away, right, in that example. But earlier we were talking about, right, a parent adding a child to their house, and you're adding liability in that case, right? And a lot of people don't really look at it and think of it that way.
No.
But that's why I think titling is so important. One of the things I wanted to talk to you about today is because I see it quite often where it's just simple little changes. Everybody thinks it's not a big deal, but they could be opening themselves up to more liability than they need. They could be making it more difficult for their estate to flow. There's just all sorts of things with titling, and liability is a big part of it.
And liability is a big part of it. And that's a big part of a lawyer's job is moving liability from one party to another, right? Yeah. So I used to do a lot of commercial contracting, a lot of work at General Motors. And that was what most of the negotiation was, is who can manage, who is the party that can bring this risk to the collaboration. That is the party that should manage it, right? So don't take on someone else's risk. And buying a boat in your name that now is, especially if you're going to loan that boat out, good idea to have it in irrevocable trust. Yeah, it is managing liability, very much so. And that's what we do with estate planning and asset protection. Mm-hmm.
So kind of switching gears here, are there strategies for titling assets upon death, or at that point, is it just too late to do anything?
There's strategies. There's definitely strategies. So, we've talked, Maya, people, especially early on in our live stream, we had many questions about a ladybird deed. What is a ladybird deed? Can I use a ladybird deed? How do I get a ladybird deed? Because people have heard this is something that is often discussed. I don't know where, but it's discussed. I don't discuss it. And so people, I think, have a point of view about a ladybird deed that it is an estate plan. I'm just going to put my house in a ladybird deed and I'm going to be done. And in fact, going on that, I actually have phone calls at times where people will call and they'll say, hey, hi, nice to meet you. Do you do ladybird deeds? And I will say, as a part of a larger strategy, I do. Well, do you just do a ladybird deed, and how much would that be? And my response is, it is very risky for you who's asking for this. Again, managing liability, the risk of me doing a ladybird deed for you. It's a little bit like you just called your doctor and said, hey, I saw this great medicine on TV and I need it, right? Without knowing what the symptoms are, who is going to benefit. I need that prescription. And so when someone calls and says, I need a ladybird deed, I don't know that they do, or I don't know that what they're thinking is really the appropriate way of moving their house. But it is a transfer on death. You talk about what can we do at death. We can transfer property using a ladybird deed, but you can really mess up your beneficiaries if you don't understand where they are. You may want to give it to your son's best friend because he has Down syndrome and you want to help him. Well, that might not benefit him. It might harm him because it will interfere with there's other ways of helping him. And if you just gave him the house, you might harm him because you just gave him an asset that he's not supposed to have. So we talked about that with supplemental needs trusts a while ago. So there are ladybird deeds. Those are after death. I mean, you've got to make the decision before death, and that's what you have to do with everything. There are transfer on death beneficiaries. You should go to your bank and at least set up a transfer on death beneficiary for your bank account, so that doesn't have to probate. The types of accounts that Tom deals with, he's an investment. He's an investment guy, right? He's a financial advisor who is giving you guidance on the best financial product for you. Those all have the ability to assign a beneficiary. And And sometimes if you do that without knowing that you can actually harm your beneficiary, that's a bad thing. Sometimes you just get lucky and it works just fine. But that's why we exist as a team. So, Tom can say, okay, I can get that we need to assign a beneficiary. Have you thought about the larger picture of your whole estate and how you want to distribute it and what your thoughts are? Maybe you should go speak with my colleague, Mary Ann. I mean, we're not, we're not on the same company by any means. We're both independent from one another, but we do work together with clients like that to help them. I don't know if I'm just rambling or if I'm helpful, but just arbitrarily assigning beneficiaries, and a ladybird arbitrarily assigns a beneficiary to a house, is not a great practice from my point of view.
Yeah, I think, looking at titling, if you listen to this and you want to go look back at all of the things that you own, right, which is basically titling, it's claiming ownership, reviewing those beneficiaries is just as important, right, as titling. Like you mentioned, bank accounts, you can attach a beneficiary to anything. It's just called different things when you do it, right? Transfer on death is like after tax checking and savings. Like on a 401k or an IRA, it's actually going to be called a beneficiary. We mentioned earlier, maybe there's two business partners, right? They're going to have a buy-sell agreement to determine how these things happen. And it kind of goes to what you were just talking about is you can go and just attach beneficiaries and have things go directly to people. And that is a way to get things done. But one of the things that I always preach is flexibility, right? Why put ourselves in a corner in a decision today when we don't have to, right? If we can allow other things to play out, then maybe that'll help us figure this decision out. So I think kind of what you were mentioning kind of puts a block in the way to where everything just doesn't flow and happens. It puts a pause on it and gives you a minute to catch your breath and say, okay, this is where we are now. Are these, same titlings? Are these same beneficiaries?
Exactly.
Are they still our desired goals that we want? Whereas if you have a trust step forward and kind of grab this stuff, it gives you a minute to come up for air instead of just everything just happening and going. Because like you said, somebody could be not wanting to get all of that money. They could be on some sort of benefits or something, so they don't want to inherit all of that. So putting those options in there, I think that the beneficiary part is just as important as titling. And that's what I've learned working with attorneys is it's great to come and sit down and have conversations with clients. I learn stuff all the time. Clients are learning stuff all the time. And it's really getting to, what are they really trying to accomplish? And then building in as much flexibility around that so that in the future, they can still zig and zag, but still get to their goal.
That's a very good way. And what you're talking about right there, building that flexibility in, is an estate planning tool called a revocable living trust. It's your real rule book, how you actually want, you send everything to the trust. Now the trust is making all of the decisions. If Johnny can't take this money right now, put it in a different kind of feature for him or move it to someone else. It really is that flexibility. And I talk to people all day long about that flexibility. Sometimes we don't put any property into a trust during their life. It's some strategy, but we put it all into that trust as a distribution mechanism at their death. So, and that flexibility is key. It really is. And I literally had a person call me the other day to say, hey, my mom died and we called her 401k company and she had her ex-husband, my stepfather, as the beneficiary. What can I do? Not much.
Yeah.
So,
it's unfortunate when you run across those.
Mm-hmm.
Yeah. So titling, beneficiaries, they should kind of go hand in hand. And again, right, sitting down with an attorney is going to be the best way to go about, discussing what should come together for all of that.
Well, it
Yeah.
sounds like this is a topic that you guys could probably spend a lot more time talking about, but
I do.
we are out of time. So any final words from you two on titling assets before we have to go?
I see someone put in the comments that their attorney had made the same recommendation. I try to say I'm not making a recommendation, right? Because it's based on individuals, but it sounds like their attorney suggested a trust as well. Yeah. So it's a very good tool.
Anything else you want to add before we go, Tom?
No, thank you so much for having me on. I appreciated it. It was great to get some of these questions. I know some clients are going to be happy to hear some of it, and some clients are not going to be happy to hear some of it. So I appreciate it. Thank you very much, Mary Ann.
Yeah, thank you, Tom, and thanks, Maya.
Yeah,
Thanks.
thank you both for joining us for this segment of Ask the Attorney. Mary Ann and I do this every month, so we will be back here in September with another segment. So if you have any questions for Mary Ann, you can always send an email to our newsroom. It's just newsroom@upnorthlive.com, and maybe just make the subject line Ask the Attorney so it's easy to find. You can also contact Mary Ann. I have her information in the comments below, but like I said, we are out of time. So thank you so much for joining us. And Mary Ann and Tom, thanks again for providing all this very important information on titling assets. Mary Ann, I will see you next time on Ask the Attorney. And Tom, it was great to meet you.
Thank you very much. It was great meeting you as well.
Thank you. Bye-bye now.
Bye, guys.